Florida bar approved CLE called Florida's third DCA, a year in review of significant opinions for the year 2020. This is a 2 credit hour free Florida bar approved CLE. This reference number here is the number you're going to need to put in on floridabar.org to get your credits. This CLE is being conducted on Zoom and is being recorded live, and it will be rebroadcasted. If you are watching this on Zoom, go to the chat function, and I am uploading a copy of the demonstrative I'm going through. If you are watching this on the rebroadcast, email me, Cullen O'Brien at culleno'brienlaw.com or wizard@floridadcawizard.com to have a copy of the demonstrative so you can go through it as you watch the rebroadcast. The CLE is being conducted by my company, Florida DCA Wizard LLC, which is a for-profit company that does real-time case law updates of significant decisions in real time. So this CLE will cover significant opinions for the third DCA for the entire year 2020. There were over 600 written opinions handed down by this third DCA in the year 2020. I'm not talking about PCAs, I'm talking about like actual written opinions with text and analysis. I read every single one, and I've selected approximately 120 total cases, and I broke them up into the subject areas that you see here. Sanctions, there's a lot of strange sanctions cases I call fairness, business dealings, procedure, jurisdiction, discovery, contracts, criminal law, evidence, and miscellaneous. Obviously, if you want to go deep into cases, we could spend like 3 hours on one case. I thought it would be more valuable here to pick out sometimes sound bites, sometimes deeper analysis, but getting a broad spectrum of things in cases that are helpful to many different types of practitioners, so that hopefully there's something in here that can help you in your practice. But that being said, because there are about 120 cases and we have fewer than 120 minutes, we're going to go quickly through some of the cases. But in the demonstrative, when you see it, there are hyperlinks to each of the cases. So if you feel you want to read the case in a little more detail or get a little more nuanced analysis, you can click on the case and read it yourself. Okay, so let's start with the first subject area. These are the procedure cases. And just so you know what this looks like, each section of cases that I've divided the cases into, and these are my arbitrary categories, have a case title with a hyperlink, an attribution of the lower court judge, it's not the appellate court judge, and a little summary to go through the summary that's coming. So there's 2 pages of summaries of procedure cases. Here we go. The first case, Bank of America versus Morales. It's Judge Guzman out of Miami-Dade County. And this was a complaint against a bank for alleged bad misconduct. And the bank moved to dismiss based on absolute litigation immunity. And the trial court required the bank to answer discovery before ruling on immunity. And the appellate court took an interlocutory appeal and said the bank was entitled to a ruling on its motion to dismiss and asserting immunity from suit before a ruling could be made compelling additional discovery. So if you have an immunity issue, you get a ruling before you have to answer any discovery. Next case, PK versus Claraway Properties, Judge Zibler out of Miami-Dade County. Here is a case where the trial court erred in not consolidating claims for fraud and breach of an agreement. There was an agreement, and then on either side, people said there was wrongdoing, and the trial court said, I'm not consolidating these cases, but the third DCA used the term inextricably intertwined, and the counterclaims were kind of related to the agreement, so they shouldn't have been severed. They should have all been tried together. This is a good case if you are looking to consolidate cases. Belson versus Miller, it's Judge Miller out of Miami-Dade County. This was a motion to strike sham pleadings that the court granted, even though the motion to strike was not verified and there was no evidentiary hearing, and the hearing wasn't noticed. So the third DCA said you have to meet all those elements. Reading from the case, The motion was not verified as required by Rule 1.150. It's undisputed that the hearing was neither noticed nor held as an evidentiary hearing, despite the clear due process requirement that all three things be the case. A good quote from the case that's applicable in other types of cases: affidavits cannot substitute for testimony and other documentary evidence that an evidentiary hearing requires. Because the proceedings were so flawed, reversed. Okay, next case, Energy Smart versus Millennium Condominium. This is a lack of prosecution case, and a lot of the jurisdictions, courts will say, hey, you haven't done anything in the case. If you don't do something, we're gonna just dismiss your case for lack of prosecution. Here, the thing that was done within the time frame was a stipulation of substitution of counsel. And the third DCA said, that's enough record activity for us to not dismiss your case. Now, down below, the court actually found that that wasn't a stipulation for substitute counsel as a sham. And the third DCA said the trial court was without discretion to sua sponte strike a stipulation for substitution of counsel. And by the way, that filing was enough to stop lack of prosecution. Next case, Poultry and Industrial Suppliers versus Incubal. It's Judge Cinnamon out of Miami-Dade County. This was a forum nonconvenience motion, and there was an affidavit filed in opposition to the forum, or in support of the forum nonconvenience. And the affidavit was from a Colombian legal expert, Colombia, the country, and said it would be a legal impossibility to litigate the claims in Colombia. The reason why this is significant is because there was no expert testimony on the other side. It appears that the third DCA is suggesting that if you have an expert in a case like this about what the other forum would be, and there's no competing expert, you win. And quoting from the case, based on the expert affidavit and no competing evidence from PIS to controvert the legal expert's opinion in this regard, the trial court properly concluded that Colombia is not an adequate and available forum for this litigation. Next case, Rodriguez versus Children's Home Society of Florida, Judge Zibler out of Miami-Dade County. Usually pro se litigants are given deference to do a lot of things and amend many times. Here, this is a rare scenario where the pro se litigant was not given additional deference beyond the third amended complaint. And it was a 61-page complaint, which is a lot. And it was prolix, very lengthy and rambling and legally insufficient claims. And the court said, yeah, we can dismiss the pro se litigant's pleadings in that case, where the pro se litigant refused to hire counsel. This is an exception to most courts you'll see that give pro se litigants a little more deference. But if you have this, from the tone of the opinion, it looked like the pro se litigant had a vendetta and wasn't sort of like personal, negligent treatment of twin daughters. Okay, next case, Walters versus Beach Villas Condos. Judge Arzola out of Miami-Dade County. This was a slip and fall on a pool dock. And this is a case where the party was allowed to amend an affirmative defense at trial. At trial. This is not like, this is like during trial, and to conform to the evidence. This is a great case on being able to amend to conform to the evidence. And the court said there was prior notice that this defense would sort of be in the mix and there was no prejudice. Great case if you want to try to amend anything, because you can say, wow, I mean, people get to amend at trial. Why can't I, to conform to the evidence? Citizens Property Insurance versus Kings Creek. This is the next case. Judge Miller out of Miami-Dade County. If you do insurance work, this is kind of in the weeds in that regard, but Citizens did not need to plead in an affirmative defense that non-wind related factors caused the damage. Usually a party is required to plead a policy exclusion as an affirmative defense. I'm quoting from the case, only when the policy exclusion is the basis for the defense, but because it was a named perils policy, if the insured failed to prove that the damage resulted from the named peril, the damage was not covered. This is, in the weeds on insurance stuff. Next case, Vasquez versus Citizens Property Insurance. Judge Miller out of Miami-Dade County. Another insurance coverage dispute regarding water intrusion damages. And there the court basically just summarily dismissed everything. It just took some motions in limine, and took an expert affidavit and was like, yeah, I'm dismissing this. And the third DCA reversed, saying neither party moved for summary judgment following the denial of reconsideration of the motion in limine order, yet the court summarily concluded that Ms. Vasquez could not recover for breach of contract. So that was overturned. Got to have notice, an opportunity to respond before a summary disposition. Hunt versus SCI Funeral Services. This is Judge Humberto Diaz out of Miami-Dade County. There were allegations that a funeral home unlawfully moved a casket containing a stepfather, and there was a summary judgment proceeding. And the third DCA found that the party was not entitled to rely on evidence that was not properly noticed pursuant to Rule 1.510C. Apparently, they tried to like cram in evidence not in accordance with the procedure of that rule. In quoting from the case, because the Hunts failed to provide notice of their summary judgment evidence, the trial court was precluded from considering any of the evidence. And the court says the notice requirement is mandatory. I want to pause for a second because I had to change my analysis of the third DCA opinions, and I took away a lot of summary judgment opinions because, like, on New Year's Eve, the Florida Supreme Court issued this amendment to Rule 1.510, and they're looking for public comment, but basically what they're trying to do is turn the summary judgment analysis in federal court into the one in state court, which basically puts the onus on the non-moving party to disprove why they should still be there, or disprove. It completely shifts the burden in a much different way than the Florida standard. And the reason why this is important, because a case like this, where notice is mandatory, but then if we change the standard, I mean, if you really read that standard, it says everything in the record, the court has to take into account everything in the record. So I think this standard is significantly inconsistent with this notice requirement. The case we just went over, Hunt, this notice requirement in the rule is mandatory. This is what the third DCA was talking about. 5 days prior to the hearing, 2 business days, you got to like provide all your evidence. I think there's going to be a significant tension in the way that the Florida Supreme Court wants to have the summary judgment standard and the practical realities of how state court cases are litigated, and there's no notice requirement. People can provide comment. I'm actually going to provide some comment, and I think it has to be by March 2nd. So if you're watching this video, that will have already passed. That time will have already passed. But I wanted to point that out, that there is like going to be a sea change in summary judgment. So I took a lot of the summary judgment opinions out of this because things are going to be much different. All comments must be filed with the court on or before March 2nd. Okay, out of that, the basic rule in Hunt is this notice requirement is mandatory. You've got to provide your evidence by notice. I don't want to spend too much more time on this, but if you're a state court practitioner, you know that some people run into court like, oh, I got this thing, or they email the judge or whatever. But the third DCA makes you hold the other side's foot to the fire that if they don't comply with the notice requirement, giving evidence in a timely manner, trial court precluded from considering it. Okay, Morales Law Group versus Rodman, judges Miller and Guzman out of Miami-Dade County. Here, a motion to quash service was properly denied. The return of service was regular on its face. The reason why I thought this was important, it looked like the lawyer on the other side was trying to say things that countered the regular service on its face. And this is a great quote that can apply to many other cases. The counsel's unsworn, I'm quoting from the case, the counsel's unsworn argument is not evidence and does not rise to the level of clear and convincing evidence that service was not validly executed. So what lawyers say is not evidence. Okay. Bello versus Giovera Specialty Insurance Company, Judge Rebel out of Miami-Dade County. Here, summary judgment was reversed. This was the scenario where the party moved for summary judgment, even though there was outstanding discovery on that party, and the trial court still granted summary judgment. And here, the third DCA said the trial court abused its discretion, quoting from the case, in denying the motion to continue in the summary judgment hearing because The other side said, well, they haven't responded to discovery. Okay, next case, Lanzo versus WNF Law, Judge Thornton out of Miami-Dade County. Here on a motion to dismiss, the trial court was not allowed to take judicial notice of a previous lawsuit along with pleadings and transcripts from that lawsuit in deciding a motion to dismiss. If you're just joining, go to the chat function, and there's a copy of the demonstrative we're going over. This is a little jarring because it's another lawsuit, but the third DCA said, no, you cannot take judicial notice of other pleadings and transcripts in another lawsuit. Quoting from the case, even though it appears that the trial court was attempting to expeditiously decide the issue on the merits, the trial court was not permitted to consider or take judicial notice of matters outside the complaint and attachments to which the motion to dismiss was directed. This is a very strict reading of the four corners rule in deciding motion to dismiss. Next case, Figueredo versus Cordero, Judge Cueto out of Miami-Dade County. You had an incarcerated individual, and the third DCA said that incarcerated individual needed to have telephonic access to a revocation of probate assets hearing. So an incarcerated party has the right to be heard in civil matters. Okay, next case, Cruz versus Lakeview Loan Servicing, Judge Zibler out of Miami-Dade County. This is a case about pleading an affirmative defense and how this affects summary judgment. And again, I don't want to belabor the point, but this is why I really have an issue on pulling up the Supreme Court's proposed change to Rule 1.510. I have a lot of different issues, but this is another example of why this is going to be a problem. They want to have the federal summary judgment standard applied to the way we work in Florida state court. And I don't know what that does to a case like this. This case says if a defendant pleads an affirmative defense, this is the Cruz case, the party moving for summary judgment must either factually refute the affirmative defenses by affidavit or establish their legal insufficiency. So this is like putting the onus, complete onus on the party moving for summary judgment regarding an affirmative defense. But the summary judgment standard that may be adopted soon, I don't know what happens to a case like Cruz. I think this rule is inconsistent with that standard. I don't want to digress, but a lot of summary judgment cases are going to change. Anyway, Howard versus Greenwich Insurance Company, Judge Hansman out of Miami-Dade County. Here, the trial court was not permitted to take judicial notice of settlement documents, that did not exist at the time the second amended complaint was filed in deciding a motion to dismiss. So apparently there were some settlement papers, and the other side said, hey, Judge, you got to dismiss these claims. We have settlement papers. And the third DCA, very strict reading of the four corners rule. They didn't exist at the time the amended complaint was filed. Quoting from the case, the court essentially transformed a motion to dismiss into an unarticulated motion for summary judgment where, as far as the appellate record shows, no motion for summary judgment had been made or argued by either Greenwich or Howard after Greenwich filed its answer. A motion to dismiss is not a substitute for a motion for summary judgment. Okay. Now on to some sanctions cases. The reason why I point out these sanctions cases is because it's a good reminder for lawyers to mind their P's and Q's, because sanctions happen from many different angles, and the appellate court's not always there to reverse the trial court. And there are some surprising ways parties or lawyers can get sanctioned. So I think it's a really good reminder to point out how people get in trouble by messing around. So let's go through some of those sanctions cases. The first one is Wanon versus Coral and Stones, Judge Miller out of Miami-Dade County. So this was a very basic lawsuit for replevin and civil theft regarding diamonds. And the trial court issued sanctions against a party for invoking that party's Fifth Amendment privilege and refusing to testify to deposition. This, when I read it, scared me. This is what happened in the trial court. The trial court order found the plaintiff, in contempt. It further provided that the plaintiff would, this is a civil case, would be taken into custody. Civil case would be taken into custody, his pleading stricken, and a default entered unless within 20 days, the plaintiff answered questions regarding his transfer of the diamonds, including disclosing the buyer and the current whereabouts of the diamonds. Now, 20 days, that means you have to file a petition for writ of certiorari or mandamus in that time, and the third DCA has to take it up. So something like this can happen. It could slip through the cracks, but it didn't here. The third DCA said, here it is apparent that the plaintiff could have reasonable grounds to believe that forcing him to disclose what he did with the diamonds could aid in his criminal prosecution. So can't sanction him for taking the fifth in a civil case. Okay, Jones versus State. If you saw one of the prior CLEs, this is a case I covered from a different angle, but the trial court was within the trial court's discretion to give a defendant 180 days. Now it's a criminal court case, mind you, but 180 days for direct criminal contempt for saying, so fuck me, basically, your courtroom is unfair. Those words, 180 days in jail inside of a courtroom. Good reminder to clients to just not say anything. Phillips versus Mitchell's Lawn Maintenance Corp. Judge Cinnamon out of Miami-Dade County. It was a civil theft case, and the third DCA thought that the trial court was right in what the trial court did, quoting from the case. This record amply supports the order striking the pleadings, demonstrating repeated, flagrant, and intentional failures to respond to discovery and appear for deposition and other dilatory and sanctionable misconduct. So failing to respond to discovery, flaunting orders, failing to appear for depositions, this is the sort of stuff that can get someone in trouble. This is a great case if you're on the side of someone doing that to you. It's a great case to use if your client is telling you that he doesn't want to comply or she doesn't want to comply. This is a good reminder case, like bad stuff can happen. Okay, Lavold versus Oracle Elevator. This is a 57-105 fees order, and the order was error because it didn't set forth the requisite findings that the claim was frivolous and completely untenable. From a practice standpoint, if you win a 57-105 motion, a lot of times in state court, you have to draft the order. If you're going to draft an order where you win, you got to make those findings very clear that the claim was frivolous and completely untenable. This is a good case of setting forth an exacting analysis. Okay, next case, Silver Law Group versus Bates. Judge Jones out of Monroe County. Another 57-105 motion, and fees on fees were not allowed in a 57-105 motion. Next case, Fernandez versus Fernandez. Judge Young out of Miami-Dade County. The trial court issued 57-105 fees against someone for filing an allegedly frivolous adult dependency petition. Usually dependency, it's a minor, but in any event, the trial court said, yeah, that's frivolous, I'm going to sanction you. But the third DCA said, wait a second, the person had Down syndrome who filed this petition and was like severely disabled. And the rule says, if you have a condition like that predates you being an adult, it's okay. You can seek adult dependent support. I'm not really saying this for get into dependency law. I'm pointing this out for how sideways a case can go if the court feels like something's going wrong. So it's just really got to mind your P's and Q's. This court, despite what appears to be a very clear common law right to seek an adult dependency support from a parent in a court of competent jurisdiction when such dependency is the result of a mental or physical incapacity which began prior and the person had Down syndrome, still got sanctioned. Very alarming. Okay, Lanson versus Reed, Judge Reboll out of Miami-Dade County. This is interesting. An evidentiary hearing for 57-105 fees was not required. Here, the third DCA said the record is very clear that the claims that were asserted over the past decade, 10 years, were legally meritless. So the court did not have to have an evidentiary hearing. He or she could just take into account the entire record. And here there was apparently a frivolous claim for legal malpractice because new lawyers had come in and they had a chance to fix it. Another interesting part of this case, the people that got sanctioned tried to oppose attorney's fees with like blanket objections, and the third DCA said that was not sufficient to oppose the attorney's fees motion. The multiple blanket objections, quoting from the case, filed by appellants in response did not comply with the order, nor did they provide legal authority on which the objections were based. It's a good reminder, you got to be detailed in your objections and try to find legal authority. Okay, next case, in re marriage of Chen and Liu. Here, the lawyer got sanctioned without notice and an opportunity to be heard because the lawyer failed to appear at a state court hearing because there was a scheduling conflict with that lawyer in a federal immigration proceeding. So the lawyer didn't show up and got sanctioned. Boom, sanctions. And the third DCA was there to reverse it, but may not happen every time. And the third DCA's analysis was, the order on review contains neither an express finding of bad faith nor the requisite high degree of specificity in the factual findings. The order was also imposed without notice and opportunity to be heard. But if you just try to put yourself in that lawyer's position, they had a federal case and they missed a state court case and they got sanctioned. So calendaring is very important. Again, mind your P's and Q's. Courts can do things that are unpredictable, like sanction you for not showing up to a hearing. Okay, next case, Diaz versus Kaczynski. It's Judge De La O out of Miami-Dade County. Here, the other side said that the side that got sanctioned should have got sanctioned even more for defending the fee petition, for saying, well, these fees aren't enough. And the third DCA said, no, you can fight a fee petition even if you've been sanctioned, even if there's a basis to sanction you. So quoting from the case, the trial court expressly found it could not justify imposing further sanctions or fees on fees against the parties based on their defense at the evidentiary hearing of this on the sanctions motion. Just defending a sanctions motion is not like a basis to get further sanctioned. Here are some contracts cases. De Soleil South Beach versus De Soleil South Beach Association. Condo association versus a different kind of association. I want to say this a little slowly. The Condominium Act, it was a Condominium Act dispute where a party that was not a party to the declaration, so like a non-party to the declaration, tried to use the declaration as an affirmative defense. And the third DCA said, if you're not a party to a contract, you cannot raise as a defense the violation of the terms of that contract because you're not a party to the contract. So this was a master association agreement. Next case, Palma versus South Florida Pulmonary and Critical Care. Some doctors had joined a medical group and the medical group took out all these loans. And then when the loans came due, the medical group said, hey, you guys were doctors when we took out the loans, so you need to repay the loans. And the third DCA said, no, if you look at the terms of the loan agreements, the doctors were, quote, mere accommodation endorsers under the promissory notes. And the purpose of the loans was funding of expenses accrued by the medical group. And it was undisputed that the medical group received the funds. So in your business dealings and contracts, I think it's very important to contemplate what happens if these people leave and whether they have to pay it back. I've actually felt good reading this that the doctors didn't have to pay that back. Okay, next case, Supercars of Miami versus Webster. Travis Scott is the famous person's name. His real last name is Webster, but he rented a Lamborghini and crashed it. And the company he rented the Lamborghini from wanted him to pay diminution in value. And the third DCA found that he didn't have to pay loss of rental income or diminution in value resulting from the accident. The plain language of the agreement was that he was solely responsible for reasonable repairs, not diminution in value. So it's a good case if you're doing contracts to be very careful to specify what the damages are. Diaz versus Navajas, Judge Hansman out of Miami-Dade County. Don't see many specific performance cases. It's like a law school kind of hypothetical, but here specific performance was like upheld regarding the sale of land. The sellers were motivated by manifestations of remorse and attempted to extricate themselves from the negotiated terms of the sale. So like they signed up to sell a house and the buyer was ready, willing, able to close. And apparently the sellers got cold feet and tried to like get out of it. And the court said, no, specific performance, you agreed to sell it. Unique case. Next case, law offices of Granoff versus Glass, Judge Cinnamon out of Miami-Dade County. Here, an attorney's claim for breach of contract against his or her own client does not require expert testimony regarding the value of the services rendered. Let me just say this another way. If you're doing like a fee petition or something, you may need expert testimony to talk about why the services were valuable or some other context. But if the attorney is suing their own client for lack of payment, that attorney does not need expert testimony to support the value of the services. It's unique. And just quoting from the case, corroboration by an independent expert on the stipulated rates and hours incurred is unnecessary if the attorney claiming the fees from his or her former client has testified regarding those matters, and the fee contract and invoices are admitted into evidence. Sort of like the benefit of the doubt goes to the attorney. Next case, Massa versus Michael Redard Hospitality, Judge Mano Schur out of Miami-Dade County. Here, the trial court erred in ordering non-signatories to an agreement to arbitrate without an evidentiary hearing. Apparently, quoting from the case, a non-signatory to an arbitration agreement may be bound to arbitrate if the non-signatory has received something more than an incidental or consequential benefit of the contract, or if the non-signatory is specifically the intended third-party beneficiary. But you have to have an evidentiary hearing in that circumstance if you're going to make a non-signatory to an agreement to arbitrate. Pinero versus Zapata, next case, Judge Ige out of Miami-Dade County. Here, the trial court was without jurisdiction to grant an extension of time to pay a settlement sum that was not part of the voluntary settlement agreement entered into by the parties. Let me say this another way. Parties had settled and there was a payment schedule, and the people with the payment schedule had to pay, said, oh, I need more time, this, that, and the other. And the third DCA said, while it's nice to help someone out, you can't. Got to enforce the terms. Quoting from the case, the trial court was obligated to enforce the mediated settlement agreement as voluntarily agreed upon by the parties. So like, you can't move the payment dates just because there's some excuse by the other side. They agreed to a settlement. This is the payment terms. They have to be followed. The trial court can't grant an extension of time from a settlement agreement. That sort of thing doesn't exist. In litigation, extension of time to respond to a motion, extension of time to do this, that, and the other, but not a settlement agreement. You can't go and rewrite the settlement agreement and put in an extension of time for payment inside the settlement agreement. Okay. Next case, People's Trust Insurance Company versus Alonzo Pombo, Judge Ige, again, out of Miami-Dade County. Here, the third DCA found that the breach of contract count was properly dismissed because the insurance company failed to identify any actual damages as a result of the alleged breach. This is an interesting case. The insurance company, quote, states that it suffered material prejudice as a result of the homeowner's failure to provide a sworn proof of loss, but still quoting from the case, but this is not measurable damages. Quote, as the insurance company has not alleged it has or will suffer any damages, the breach of contract count cannot be sustained. A lot of times people get away with saying, yeah, and it's material prejudice, but this is a very interesting case. If you have speculative damages, you may be able to hold someone's feet to the fire and get the case dismissed. Or if not that, maybe a motion for a more definite statement. Next case, waterproofing and roofing, design versus Ashworth, Judge Rodriguez out of Miami-Dade County. There was somebody who was not paid for roofing work, and they filed a civil theft claim. And the third DCA said, no, you not being paid for roofing work is not civil theft. And then it was like one of these cases where there's all these alternative causes of action. And the third DCA said, as a matter of law, the existence of the contract between the parties defeats implied contract and quasi-contract claims, and this isn't civil theft, just not being paid for roofing work. There's a contract. Let's decide whether there was a breach. Don't add on extra stuff to a contract claim. That's my takeaway. Gillen versus Rodriguez, Judge Cinnamon out of Miami-Dade County. It's a short opinion. It's hard to really know what the emails were. But number one, this case stands for the proposition that the email exchange was a settlement. There's a bunch of other cases on this point, but this is yet another case to add to if someone in an email consents to an offer and hold them to the email. The other thing that I thought was important from this case is that the court said the absence of a transcript prohibited the appellate court from reviewing the order, and the order compelled enforcement of the emails. And the other side said, yeah, all this bad stuff happened, and the third DCA said, well, you don't have a transcript. Like, we can't review the order. So this is one of a couple other examples, but just a reminder, clients don't like paying for transcripts, but a situation like this is exactly why you need to have a transcript. Like the 10 hearings where you didn't need it, here's the 11th where like it actually matters, costs a little bit more, but it can save your appeal. I mean, the appellate court didn't even give him an audience because there was no transcript. Okay, here are some cases I deemed called fairness, because like a lot of strange things happened, and I couldn't think of a better category than fairness. Okay. Here, Samra versus Bedoyan. The third DCA doesn't say on these disqualification orders the name of the judge. So I don't know what judge it was or which county, whether it was Miami-Dade or Monroe. But in any event, the third DCA said that the trial court should have been disqualified after writing an order that stated that the party engaged in, quote, salacious, horrifying, improper maneuvers which derailed the case. So I guess if you get a court order where there's some language like that, could be a very good basis to disqualify the trial court. Another case, Marwan versus Samud. The third DCA said that the trial court should have been disqualified because the judge was asking a, quote, disproportionately higher amount of questions of a witness on an issue. So sometimes judges will jump in to some sort of evidentiary hearing, sometimes a bench trial, sometimes even a jury trial, and we'll start asking questions. This case stands for the proposition that if the court does that in a manner that for witnesses that help one side, but not to witnesses that help the other side, or witnesses that hurt one side and not to witnesses that hurt the other side, that could be a basis for disqualification. Another case, Yerby versus State. This is a bond hearing for criminal defense practitioners, but the trial court erred by not considering evidence at a bond hearing. Quoting from the case, in order to make a bond determination and exercise its discretion, the trial court must take evidence and make findings on the statutory factors. And here, the trial court, quoting from the case, did not hear any testimony, take any evidence, or make any factual findings regarding any of the statutory factors. Like literally just said, I'm not going to consider anything. And the third DCA said, no, trial court has to consider evidence. Okay. Next case, SS versus DCF. Quoting from the case, the judge's commentary concerning the credibility of the petitioner and family members before the completion of the petitioner's direct examination or presentation of any witnesses in support of her case is sufficient to create in a reasonably prudent person a well-founded fear that she would not receive a fair hearing before the judge. It's difficult because sometimes judges, rightfully so, engage in a manner that they're with candor, but a case like this shows you that judges should be careful saying too much because they can get disqualified. Okay. Bank of New York Mellon versus Hernandez, Judge Miller out of Miami-Dade County. This was a summary dismissal. And quoting from the case, the trial court's dismissal of the bank's case without a pending motion and based solely on its legal conclusion drawn from proffered testimony prior to the presentation of any evidence was improper. Like a great quote from the case is, a trial court cannot dismiss a cause of action without a pending motion or objection. And another great quote from the case, it is a due process violation for a trial court to sua sponte, dismiss a claim without notice or a hearing. So I don't know if they had a transcript, but a case like this is a perfect example why you need a transcript at every proceeding. They showed up to the hearing and they got their case dismissed. So like, who would have predicted that? In any event, trial court can't do that. Due process violation. Okay. Afanizev versus Alvarez, Judge Sanchez Lorenz out of Miami-Dade County. This was a due process violation for the trial court to, quote, sua sponte, issue a stay away order and the parties pending dissolution of marriage action and granting temporary exclusive use and possession of the marital home when those issues were not before the court and they weren't noticed for a hearing. So they showed up to a hearing and all of a sudden there's a stay away order and an order granting temporary exclusive use and possession of the marital home. I covered this in a couple CLEs ago. This was one of the exemplary cases, but what happens at a hearing, the issues have to be noticed, period. And this is a very good example of that. So it's difficult in practice to hold the judge's feet to the fire or the other side, because you don't want to seem like you're being difficult, but stuff gets discussed at a hearing that's not noticed. It's technically not fair. And you probably will win your appeal if you have an adverse adjudication that was not for an issue that was not noticed. Fernandez versus State. The disqualification of the trial court should have happened where there was an allegation of, quote, a contentious exchange between the lawyer and the trial judge, culminating in the judge's instruction to his bailiff to escort the lawyer out of his courtroom. Kind of seems obvious. Like, yeah, maybe we should do this in front of a different judge, but here, I guess it wasn't. And the third DCA said, yeah, something like that happens. Let's try a new judge. Okay, next case, in re guardianship of Myra Acosta, Judge Figueroa out of Miami-Dade County. This is an interesting case. The trial court found a party in contempt for violating an order, but it was a vague and ambiguous order. So the quote from the case is, a party cannot be sanctioned for contempt for violating a court directive or order which is not clear and definite as to how a party is to comply with the court's command. Now, courts are very busy. A lot of times parties write the order for the court to sign. This is a very good reminder of being precise and specific, thinking ahead, like, how do I enforce this if the other side doesn't comply? Let's say you win the order. So passive voice or indefinite action, it's difficult. I mean, you might as well not win the order because you can't enforce it if it's vague and ambiguous. Now, it would be very risky from the other side to say, I'm not going to, it's vague and ambiguous, try to sanction me. But that would be super risky. But it's a good reminder to be very precise in language here. Okay, next case, Perez versus Soriano, Judge Sardui out of Miami-Dade County. This is an interesting one. The trial court had evidence that this party had like headache problems, not like hospital sick, but actually did go to the hospital, but like, hey, I've got like this bad headache issue. And the trial court's like, no, I'm not granting a continuance based on that. And the third DCA said, yeah, you should have granted a continuance because the trial court, quoting from the case, conducted the hearing attended only by the former husband and rendered an order the following day awarding him like over $50,000. And, just the third DCA said, look, in moving for rehearing, the former wife provided the trial court with documents from her doctors, showed she had like headache problem. Quoting from the case, one of the punchlines. The trial court's disregard of allegations made in good faith, coupled with supporting unrebutted evidence here, was an abuse of discretion. So this is, you really got to like have sympathy when people have health problems. Okay. Samra versus Bedoyan, Judge Sanchez Lorenz out of Miami-Dade County. Again, this is a civil contempt order in a civil case. So like stuff like this can happen, and the court did a contempt order and holding onto passports, but the third DCA said that was a problem and reversible error because there was no provision on how the parties would get their passports back. The language from the order was passports shall remain in the custody of the clerk of courts until further notice. Like the court just issued an order, the passport shall remain, and this was written down, shall remain in the custody of the clerk of courts until further notice. Like the third DCA found that this was not right because how do we get our passports back? But I think this order was preceded by a lot of stuff that maybe if they made different choices, the court wouldn't have gotten to the point where the court made this order. So mind your P's and Q's because stuff like this can happen. Okay, Murphy versus Collins. Here, the trial court should have been disqualified because the trial court's alleged characterization of the plaintiff's counsel as engaging in ploys, and having a history of filing late motions and blaming court staff, that was enough. So if a trial court says that the lawyers have a history of filing late stuff or engages in ploys, making delays, that's enough to get a new judge. Okay, next case, Lee versus Matsuda, Judge Cuervo out of Miami-Dade County. The trial court should not have summarily denied a motion to vacate a stalking injunction without a hearing, without providing reasons for denying the motion. So someone said, hey, the stalking injunction, I want to vacate it. Court did not even provide a hearing or give reasons for why the motion was denied. Self-explanatory. Another case, We the Best Music versus Stafford, Judge Treywick out of Miami-Dade County. There's a lot here. So there's two things that happen. I'll go through it in more detail. The one thing that I thought was interesting is like the other side called the other side a fraud in front of a jury and said the other side had a lying mouth. So this would be good fodder for like a motion in limine, an example of why if there's charged language in the proceedings, this is a great case to move in limine to stop the other side from saying fraud and lying mouth and stuff. The other thing that happened, which I thought was interesting and unfortunately does happen, is the other side misrepresented to the court about a stipulation of a document. So a new trial was warranted because the one party's counsel called the other party a fraud and stated that they had a lying mouth in front of the jury. Okay, that's one issue. The next issue is it came to a point where like they were submitting documents into evidence, and they had a stipulation that this fire rescue report had been stipulated to be admitted into evidence. And the other side's like, oh yeah, no, there's no stipulation. And so then they went forward without this thing in evidence. So shady stuff can overturn a trial. And this is it makes me feel good that if you don't follow the rules, it has a consequence. Another fairness case, Rodriguez versus Falcones, Judge Diaz out of Miami-Dade County. This is one of the few surprisingly COVID-related cases that I saw. Actually, in any of the 5 DCAs here, and I'm sure you've heard someone talk about it or maybe thought like, oh, I wonder what, like, oh, I'll just blame it on COVID that I couldn't do this, or COVID, I couldn't really talk to my lawyer. Here, there was a default, and they said, oh yeah, court, vacate the default because COVID, and I can't communicate with my lawyer and COVID. This trial court took the microscope on that argument and said, wait a second, COVID, the courts were open. So like you could have, no, that doesn't work. And then couldn't talk to your lawyer. Well, you were doing other stuff with your lawyer like around the same time. So yeah, no, COVID and I can't talk to my lawyer, that's not going to work. I thought this was interesting. I've seen COVID excuses. So this is a good case that the court will hold your feet to the fire if you're going to blame something on COVID. Okay, got some business dealings cases. This is a 2-hour CLE. We're going to stop for a 5-minute break at about 1 o'clock. So I'm going to go through some of the business dealings cases, and then I'll give you guys notice, and then we'll stop for 5 minutes. So I characterize this as business dealings because just associations between either people or entities in or about a business setting. Okay, the first case, Espinosa versus Pavel Pardo Investments. It's Judge Asharte out of Miami-Dade County. Here, this person allegedly stole from the company, a shareholder allegedly stole from the company. And they said to the trial court, hey, revoke their shares. If they forfeit their shares, they stole from the company. In this case, the third DCA said, can't do that. There's nothing in the Florida LLC Act that allows you to revoke someone's shares if they steal from the company. And then they went into the operating agreement, the plain language of the operating agreement, and there was nothing there that would allow someone to have their shares forfeited if they steal from the company. So I guess on the flip side, if you are doing corporate type documents, you may want to put in there, like if you steal from the company, you lose your shares, because this third DCA case says you can do that if it's in the operating agreement, but it's not a default provision of the act. Okay. Luckman versus Wills, Judge Garcia out of Monroe County. Horrible scenario. Chica Lodge on US 1, down in the Keys. They drove, like someone at Chica Lodge drove someone who was staying at Chica Lodge to US 1, and then that person tried to cross US 1 and got killed. And the family sued Chica Lodge, and the third DCA said, no, it's not going to work. And Chica Lodge, quoting from the case, operated different complementary transportation services to local destinations. They didn't own any property on the other side of US 1. The golf cart service was prohibited on public roads beyond the lodge's property. So once they drop off the guest, it's up, it's on the guest, and they drop the guest off at the edge of Chica Lodge's property. So horrible case, but a very good business dealing sort of premises liability case to construct policies. SGIC Strategic Global versus Burger King, Judge Thomas out of Miami-Dade County. Here, the trial court properly dismissed an action so that it could be litigated in Germany pursuant to a forum selection clause in a franchise agreement. What I thought was interesting about this case is that you see some of the factors as to why to transfer a case. And you say some of the documents are located in wherever. With the internet and Dropbox and all that, documents being in another forum is less and less of a compelling factor as to why you should transfer something to that forum. But here, many of the documents quoting from the case are in German and require translation. So I think the hook is if there are documents somewhere and then somebody has to translate those documents, that strengthens the documents being somewhere else argument. So anyway, thought that was very interesting. Okay, next case, Pritchard versus Levin, Judge Cinnamon out of Miami-Dade County. Here, this person retired and came to an agreement with the business, and then tried to sue the people by saying that he was defrauded into retiring. So the blurb I have is the party could not establish that the company fraudulently got him to retire in order to take the party's potential earnings away from him and the corporate buyout that took place after the retirement. So there was like a retirement, and then all of a sudden, this person thought that the company did all these great things, that they were just trying to get him to retire so that they could enjoy the things without him being there. And the crux of the argument, quoting from the case, is that he would have wanted to know about these negotiations because he was familiar with the reputation for aggressive acquisitions, and he would not have retired. He had just known like all this stuff was going on. And the third DCA said, no, there was no documentary or testimonial evidence suggesting that any of the executives ever discussed or considered whether the offers should be disclosed or that they expected negotiations to resume. So you feel bad about this transaction, but they weren't trying to shut you out. Interesting employment type situation. Another sort of similar case, GVK International Business Group versus Levkowitz, Judge Miller out of Miami-Dade County. Here, the third DCA affirmed a motion to dismiss a case alleging a tort arising from the failure to disclose certain financial interests in aviation equipment. It's a little convoluted, the opinion, but in essence, the takeaway, it's kind of the same takeaway as the Pritchard versus Levin case, is that there was no fiduciary duty to the plaintiff to proactively disclose facts relating to business dealings that could have been discovered through due diligence. So do your due diligence if you want to get out of something. Quintero versus Diaz, Judge Arzola out of Miami-Dade County. Here, a mayor wrote a termination letter and was sued for defamation. And the third DCA said the mayor had absolute immunity from defamation regarding the termination letter. Quoting from the case, the parties here have stipulated that Diaz was acting in his official capacity as the mayor of Sweetwater and within the scope of his duties when he issued the termination letter. Thus, Diaz, as the mayor, enjoys absolute immunity from statements contained in the termination letter as they are shielded by privilege from suit. Next case, Johnny's Pool Center versus Forever Pools, Judge Zibler out of Miami-Dade County. This is a minimum contacts case. A party to a pool tile installation contract did not have sufficient minimum contacts for the purposes of jurisdiction. Payments were supposed to have been made in Florida, but that was not alone to show that the party had sufficient minimum contacts to be brought to suit in Florida. Quoting from the case, the entire purpose of the contract was the installation of tiles and 2 pools being constructed in Puerto Rico. Although some minimal preparation for the project may have occurred in Miami, the only substantial services were contemplated to be provided and were provided in Puerto Rico. So this is actually surprising because I thought that, some of the project had been done, or it was supposed to be done in Miami, but what came down to the main argument was failing to pay in Florida. That was not sufficient for minimum contacts. Okay, so we're about halfway done. Going to take a 5-minute break and come back at 1:05. So I will see you guys at 1:05 to finish the second half of the cases. Okay, back for the second hour of the CLE. It's Florida's third DCA year in review of significant opinions. The CLE is on Zoom. It's being recorded live right now if you're on Zoom, and it will be rebroadcasted. We're going over a demonstrative that has hyperlinks to cases. If you want to have a copy of the demonstrative, which I would recommend, email me wizard@floridadcawizard.com for a copy of it, or cullen@cullenobrien.com for a copy of it. This CLE is covering significant opinions in the third DCA for the entire year 2020. There were over 600 written opinions, not PCAs, but written opinions handed down by the third DCA. And I took about 120 cases that I thought were significant in different subject areas, enough of a broad brushstroke that hopefully something in here somewhere will be helpful to you in your practice currently or in the future. I broke it up into arbitrary sections. There are hyperlinks in the cases for you to read the cases in more depth and detail. I cannot discuss everything about the cases, otherwise we wouldn't get through many cases. So I'm trying to give broad brushstroke bullet points of things that I think are interesting from cases that I think will be helpful, significant to people's practice. So we are on the business dealings section, and we just ended with Johnny's Pool Center. So I'm going to go to the next case. Next case is Damaset Corporation versus Sidway. It's Judge Butchko out of Miami-Dade County. And here there were sufficient contacts for personal jurisdiction. Quoting from the case, the record discloses that through a Panamanian corporation, Damaset owned real estate and maintained its brokerage and banking accounts in Aventura and Miami. As the company was a closely held family entity for accumulating assets in Florida and transacting business here, Damaset's presence and activities satisfy the twin prongs required to support personal jurisdiction. These are great data points for showing why someone should be subject to, or a corporation should be subject to personal jurisdictions. You look at where the banking accounts are, whether it's a closely held company, what the purpose of the company. These are all this is very good data if you want to oppose a motion to dismiss for lack of personal jurisdiction. Okay. Allied Tube and Conduit Corporation versus Latitude on the River Condominium Association. Judge Bailey out of Miami-Dade County. This is one of the few class action decisions. Here, the trial court properly certified a class regarding a defective fire sprinkler system throughout the building. Defective fire sprinkler system, but the argument for in opposition to class certification was damages. And a lot of times damages the difference in damages does not prevent class certification. And this is a great case that reinforces that principle. Just because there are someone's dresser may be at issue and someone's paintings or whatever, it's still the same fire sprinkler system throughout the building. So differential damages is not a barrier to class certification. This is a very good case for the class action bar. Next case, City of Miami Beach versus 3098 Alton Road. Judge Bailey out of Miami-Dade County. This disturbed me to see this. Here, the city was required to restore water and sewer service to a property because the disconnection or refusal to resume service was based on fines or violations of ordinances unrelated to the utility, and that was arbitrary. So in other words, the city just shut off the water and service because of something else that was going on. That was disturbing to me. And quoting from the case, the fines accrued by the property owner, although linked to the same property receiving the water service, were for violations of ordinances unrelated and collateral to the utility. Because the city's disconnection or refusal to resume the service based on such fines was arbitrary, we do not conclude that the lower court abused its discretion in issuing a writ. Interesting case. Okay, Arbitrage Fund versus Petty. Judge Thomas out of Miami-Dade County. Here, the shareholders had standing to bring direct shareholder claims, given what would happen to their stock in the merger. This is a little bit in the weeds of shareholder standing, but it's like, this is a very significant case if you've ever practiced in this area, because there's a difference between a direct suit and a derivative suit. And there are a few cases that articulate the difference between direct and derivative in Florida. Mostly people look to Delaware, but here is a Florida case saying that if you are merged out in a corporation, you still have a direct action. The significance of direct versus derivative is you lose standing if it's derivative once the company is no longer in existence. There are pre-suit filing requirements for a derivative action, like a demand on the board. There are other impediments to actually bringing the case. But if you have a direct lawsuit, you can have a class action and you don't lose standing after the corporation's bought up in the merger. So the standard articulated here, a shareholder can only bring a direct suit if the damages are unrelated to the damages sustained by the company, and the company would have no right to recover in its own action. Derivative means you're bringing an action on behalf of the company. This is like a harm to the company. And here the third DCA said, even though other shareholders are similarly situated and unable to retain their equity when the merger happens, just because all the shareholders are kind of hurt, it doesn't mean it's not a special injury. It doesn't mean it's not a direct action. Very, very significant case in the merger world for shareholders. Another case, 2711 Hollywood Beach versus TRG Holiday, Judge Bailey out of Miami-Dade County. There were leaks in a fire suppression system, and the fire suppression system was part of the building purchased. So because of that, the economic loss rule precluded claims against the manufacturer. The quote from this case, if you've dealt with the economic loss rule, this is a good thing to put out in your mind, that to the extent a product's liability claim arises in the context of real estate, product's liability claim arises in the context of real estate, the economic loss rule applies. Next case, Delgado versus Miller, Judge Cuesta out of Miami-Dade County. This was a paternity action, and a lot of stuff going on in the case, but the court sua sponte issued a gag order prohibiting social media postings and contact with former clients and employees. And the third DCA said, no, that's overbroad and a prior restraint on speech. Again, there's a lot in the opinion, but here's a good punchline quote. Neither the trial court nor the general magistrate made findings of necessity, nor did they engage in any tailoring to narrow or limit the scope of those extrajudicial statements substantially likely to materially prejudice the trial. Again, a sua sponte gag order. You can't post on social media, and you can't have any contact with the former client's employees. And this was a paternity action. Anyway, indeed, paragraph 15 of the order, which purports to prohibit either party from, quote, engaging in any social media of any nature, which comments directly or indirectly on the other party's emotional or mental health or personal behavior, is so overbroad as to render its boundaries indiscernible. So this is a good First Amendment case. I put it under business dealings because it's social media related. Okay, BEO Management versus Horta, Judge Miller out of Miami-Dade County. Here, this is a veil piercing case. You probably hear it's really hard to pierce the corporate veil. Here is a case that supports why it's hard to pierce the corporate veil. The trial court should not have pierced the corporate veil. Quoting from there was insufficient evidence, and now I'm quoting from the case, that Mejia misused BEO and Cuzco to the point that they lost their independent existences, that Mejia used these two corporations for a fraudulent or improper purpose in the disputed transaction, or that their injuries were caused by such fraudulent or improper purpose. This, while it shows that the corporate veil is hard to pierce, if you're trying to pierce a corporate veil, you want to take these data points and show what these guys didn't show in piercing the veil. Next case, Lazari versus Guzman, Judge Trawick out of Miami-Dade County. This is a medical malpractice case regarding the failure to prescribe anticoagulants to the plaintiff, and resulted in some disabilities. This was a teaching hospital where this happened. So the doctor was at a teaching hospital, and the third DCA said because the doctor was at a teaching hospital, he was an agent of the medical school and was entitled to sovereign immunity. Quoting from the case, the operating agreement clearly conferred sovereign immunity upon the university for its services in treating patients at Jackson. Pursuant to the statutes, the operating agreement states that the university and any faculty member or other employee or agent of the university, while acting pursuant to this agreement, does so as an agent of the trust. So therefore, this guy was acting as a statutory agent, and everybody's immune. Okay, next case, Escadote versus Ocean 3, Judge Trawick out of Miami-Dade County. This was a leaky roof case, and I actually really liked this case because it makes me have confidence in settlement agreements. Here, there was a release signed with a condominium association regarding the leak, but then they were sued about the leak. And the third DCA said, wait a second, you released, I'll just quote from the case, by specifically releasing claims out of or resulting from property damage that occurred from the inception of the 2006 case up until March 24, 2010, the 2010 release carved out only those claims that were related to the damaged roof while preserving claims for damages with respect to other common elements. So there is no dispute that the water intrusion was continuous and resulted from the same damaged roof that existed prior to the release. So you released it, don't sue again, release upheld. It's a very heartening case, because sometimes when you have releases for clients, you're like, oh, how's this gonna play out? This is a great example of pre-existing stuff that's described in a release will be barred. This, however, is good, a good indicator that you need to be very specific in your release so that there are no ambiguities, so a result like this can't happen. Okay, Cuomo Trading versus World Contract, Judge Bokor out of Miami-Dade County, who's now a third DCA judge. Judge Bokor is. The trial court found that the party could not keep goods for the vessel installation where the plaintiff failed to install them. So the repudiation was not a viable affirmative defense. I'll just quote from the case. This is an interesting case in terms of certain business dealings. Quoting, seller was obligated to install the goods at no charge on a vessel belonging to buyer's client, but seller failed to perform the installation work. Rather than terminate or otherwise repudiate the parties' agreement, buyer elected to keep the goods and perform the installation work itself. Buyer profited from this decision by charging its client for the installation services at a significant markup. When seller sued buyer for the buyer's refusal to make the last installment payment due to seller, buyer asserted as an affirmative defense that it was justified in withholding the final payment because buyer was entitled to repudiate the entire agreement based on the seller's failure to perform the installation work. You know, that's it. The whole thing's gone. And the trial court, quote, rejected buyer's affirmative defense because buyer had affirmed the parties' agreement, kept the goods, and had not been damaged by the breach. Kind of like a law school hypothetical. Anyway, next case. Wallace versus Comprehensive Personal Care Services, Judge Glazer out of Miami-Dade County. Here, there were allegations sufficient to state a cause of action to remove a party as a trustee. A little dicey, you know, a lot of times it's difficult to show that a trustee is somehow abusing trust and they need to be removed or whatnot, but this is a good roadmap on how to know whether your case has merit. The quote, the trustee's mental condition rendered him unable to serve in that capacity, as evident from certain large and inappropriate gifts that the trustee made from trust assets to new friends who were not beneficiaries of the trust. Okay, on to some cases that I took snippets from relative to, quote, jurisdiction. Rojas versus Galamini, Judge Diaz out of Miami-Dade County. The party's motion to dismiss for lack of personal jurisdiction should have been granted. Quoting from the case, the borrower, the sole shareholder of Alba, received a loan from Galamini, the lender, also Venezuelan, after alleged negotiations taking place outside of Florida, but requiring payment within the state. Excuse me. Just because there's payment in the state doesn't mean there's personal jurisdiction. Negotiations took place outside of Florida. Payment in the state does not give you jurisdiction. Okay, Metalones versus East Group Properties, Judge Thomas out of Miami-Dade County. This is an interesting one. The party filed a voluntary dismissal rather than accepting dismissal with prejudice. But by doing that, the party couldn't appeal. So I'll just quote from the case. It is well settled that once an appellant takes a voluntary dismissal, he cannot challenge the trial court's earlier rulings. Quote, the voluntary dismissal terminated the lawsuit, thereby divesting the trial court of jurisdiction and depriving this court of appellate jurisdiction to review pre-dismissal orders of the trial court. So essentially what was going on, this party didn't want to get dismissed with prejudice because somehow the party thought that would be super bad. But what they didn't realize, by voluntarily dismissing before dismissal with prejudice, they couldn't appeal anything. So they should have taken the dismissal with prejudice, and the dismissal with prejudice gives the trial court, dismissal with prejudice gives the appellate court the jurisdiction to review any decision of the trial court prior to the dismissal with prejudice. So get dismissed with prejudice, appeal that, and appeal every other order that preceded it. But if you voluntarily dismiss, you can't appeal anything. Okay, next case, Rudman versus Numismatic Guarantee Corp, Judge Ely out of Miami-Dade County. This is about the language in forum selection clauses, where a forum selection clause says that the parties, quote, merely consent to jurisdiction in a locale. It's not a mandatory forum provision that the parties must only litigate in that locale. So if you want to make sure that people have to litigate in a certain jurisdiction, consenting to jurisdiction is not enough. You have to say, like, must litigate, something like that. Consent is not the same as must. So quoting from the case, plainly, the subject provision does not contain the words of exclusivity, like must, inherent in mandatory forum selection clauses. We therefore have little difficulty concluding that the language in the subject clause is merely permissive and does not require the case to be transferred to Sarasota County. So merely consent is not must. So you got to say must if it has to be somewhere else. Katz Luongo versus Amortegui, Judge Trawick out of Miami-Dade County. This was interesting. If you've ever tried to serve someone outside of the United States, it didn't get into the Hague Convention type stuff, but so we had a Venezuelan citizen and they were served in Venezuela. So it's like, oh, they're Venezuelan. Let's serve in Venezuela. Venezuelan citizen, serve in Venezuela. What's the problem? And the third DCA said, well, the problem is the usual place of abode was actually in Colombia, the country. So just because they were a Venezuelan citizen and they were in Venezuela when they were served, not good. Quoting from the case, it is well settled that for purposes of the statute, a person can only have one usual place of abode, the place that they're living at the time the service is made. They're living in Colombia, they happen to be in Venezuela, living in Colombia, service no good. Okay, next case. Palace Resorts Travel versus Flynn, Judge Lopez out of Miami-Dade County. Here, a forum non-convenience motion was properly denied. Quoting from the case, Flynn, a United States citizen, though not a Florida resident, allegedly was injured in a slip and fall at a Mexican resort operated by Palace Resort. So Mexican resort, slip and fall there. Flynn filed her personal injury lawsuit in Miami-Dade County. 2 of the 4 Palace Resort defendants are Delaware corporations domiciled in Florida. The trial court found that Palace Resorts conducted business in the United States, including marketing to customers of the Mexican resort. So no, forum nonconvenience denied, subject to suit here in Florida. Okay, next case, Ochoa versus Vargas, Judge Thomas out of Miami-Dade County. Here, there was a forum nonconvenience motion based on like this fear of litigating in Mexico. And the 3rd DCA said, no, that fear of litigating in Mexico was not sufficient. So here to defeat a motion for motion to dismiss for forum nonconvenience, quoting from the case, the record demonstrates that the trial court considered the fear of litigating in Mexico. We're scared to litigate in Mexico. Don't transfer this case to Mexico. Quoting from the case, their safety concerns were raised below in their response to the motion to dismiss and in the reply. Moreover, the trial court weighed the results of the prior litigation in federal court, which addressed the safety concerns. Finally, there was evidence that they have filed numerous proceedings in Mexico. So don't say you're scared to litigate in Mexico. You've filed cases in Mexico. What are you talking about? So fear of litigating in Mexico was insufficient to keep the case from being transferred to Mexico. Another case, Williamson versus Prime Sports. Judge Miller out of Miami-Dade County. This is Zion Williamson. The trial court erred in failing to grant his motion to dismiss for lack of personal jurisdiction and a breach of contract action by his agent. Choice of law. This case stands for the proposition that choice of law is not enough to establish jurisdiction. So that's one prong. Just going back to the other case, this sort of merely consent to jurisdiction and Florida law applies. That's not going to be enough to require personal jurisdiction. So just because Florida law applies doesn't mean that Zion Williamson agreed to establish jurisdiction, and there were no contractual acts that were required to be performed in Florida, therefore no personal jurisdiction. Some quotes from the case. I'll just say it again. A choice of law provision alone is insufficient to subject a non-resident defendant to personal jurisdiction. And then quoting from the case more, Prime Sports contends that its affidavit expanded on the allegations by averring that all of Williamson's requests, including the request to meet in California, were directed to plaintiffs in Florida. Like, we want to meet you in California, but you directed it to someone in Florida. But it was not the request to meet that were allegedly fraudulent, but the reasons for requesting the marketing plan. The affidavit does not say anything about the allegedly fraudulent reasons for requesting the marketing plan being directed to Florida. It simply states that the invitations to an all-person meeting outside of Florida were sent by Williamson to Florida phone numbers, email addresses, and office addresses. If you've litigated personal jurisdiction, forum nonconvenience, stuff of that nature, these are really good data points as to what an affidavit or facts you want to develop, because these were not sufficient facts to establish personal jurisdiction. Okay, on to some discovery cases. Not many of them that I thought were noteworthy, but here are a couple. Another class action case. This is Miami-Dade versus Eastern Partners. Judge Cinnamon out of Miami-Dade County. This is not a good case for class action practitioners on the plaintiff side, but in any event, the quote is, in a putative class action case, a trial court departs from the essential requirements of law when it compels merits discovery prior to its determining whether a plaintiff has standing to serve as a class representative. What this says to me, this is a good case for a defendant to advance the standing issue prior to having to turn over a bunch of class action discovery. And then essential requirements of the law is a buzzword for petition for writ of certiorari is going to be granted if the trial court has not determined whether the plaintiff has standing. This is very difficult because then you have to litigate standing, and it takes away from the meat of the case, which is the class-wide discovery. Anyway, Next case, Owusu versus City of Miami, Judge Santovenia out of Miami-Dade County. Here, there was an unsuccessful interlocutory review of the trial court's order saying he couldn't have a deposition in a Public Records Act case. And the reason why I'm quoting this, the quote is, orders having the effect of denying discovery are almost invariably not reviewable by certiorari because of the absence of irreparable harm. I just showed you a case where discovery orders are reviewable, essential requirements of the law, and I'm going to show you some more. But I point this out, this is a good practice pointer, because when you talk to your client about adverse discovery orders, what the third DCA is telling us is that, like, please don't bring an appeal of like some discovery issue. Like, it's really, really rare that it happens. So in talking to your client about the risks, et cetera, I think this is a very important data point. Like, if you lose something in discovery, it may not be worth wasting the time and resources fighting in the appellate court, because you may just get denied. So I think change your strategy accordingly. Okay, next case, Katz versus Rosen, Judge Butchko out of Miami-Dade County. The party here was not entitled to personal financial records in discovery. This was a case regarding beneficiaries of an estate. Just quoting from the case, all causes of action alleged by the complaint relate to whether the beneficiaries were entitled to 30% of their stepfather's net estate upon his death and whether they actually received it. Therefore, all duties and breaches attributed to the attorneys ultimately arise and are with reference to the face of the agreement. But then the parties like wanted all the financial records of the other side. And the third DCA said, we're dealing with like distribution of pursuant to an agreement. So, quote, the argument that despite a clear and unambiguous agreement, the parties actually intended that the stepfather could later defeat the gift made therein is not a defense to the cause of action, and nothing in the elements of those claims bears any relation to the beneficiary's present economic status. So you don't get to know like how much money that the other side has. We're just dealing with whether they should get the money, get the money pursuant to this agreement. In other words, they were in my opinion, they were overreaching and asking for personal financial records of the other side when they were just fighting over distribution of money pursuant to an agreement. Okay, Fair Haven Center versus estate of Dumitri Nikula, Judge Riamberto Diaz out of Miami-Dade County. The trial court erred in compelling documents in a nursing home abuse case. Quoting from the case, the trial court improperly compelled production of the requested documents on the assumption that the documents are public record without, number one, determining the relevancy of the requested documents to the issue framed by the pleading, two, taking any steps to protect the information, or three, providing specific findings or explanations to support its ruling. So although the third DCA said orders having the effect of denying discovery are almost invariably not reviewable, that's denying, but there are certain things that a court can do, lack of specific findings and relevancy and stuff that could trigger appellate review. Okay, next case, UBS Financial Services versus Efron. It's Judge Eig out of Miami-Dade County. And this is a case about a foreign affiliate of a company and trying to get records of the foreign affiliate. So like you have company A operating, such and such USA Inc. operating in the USA, and then you want to get records of like the bigger corporation out somewhere else. The third DCA said here that there wasn't enough of a showing to justify the bigger corporation giving up the documents when you're only suing the USA corporation. So quoting from the case, when a party seeks to compel a domestic corporation to produce the records of a foreign affiliate without piercing the corporate veil, the party must carry the burden to prove that the domestic corporation has regular access to the records of the foreign affiliate, sufficient to establish the domestic corporation's control of and legal right to obtain the records of the foreign affiliate. So this means like the USA component needs to be in control of and like snap their fingers and get the records. And here, that wasn't shown in what they did, which wasn't enough, quoting from the case. In making his claim, the plaintiff relied on the fact that the corporations are part of the same extended corporate family and share the brand UBS. This evidence fell woefully short of meeting his burden. In other words, well, they're both UBS. Like UBS America can get UBS wherever. And the third DCA said, no, that's not enough. You got to show like actual control and a right to obtain records. Okay. Next case, Stivelman versus Stivelman, Judge Cuesta out of Miami-Dade County. This could have been on the sanctions side. It's a little convoluted, but I'll try to slow it down. Here, a protective order was upheld. A party unsuccessfully tried to quash an order granting motions for protective orders and sanctions. What happened is that there were some trial court orders regarding discovery, and this party tried to like circumvent them. So, and then the other side said, I'm going to move for a protective order because what this party is doing is like circumventing discovery orders. Sometimes you can see that, and this is a good case to show that courts hold people's feet to the fire. Quoting from the case, the record shows that the former wife has attempted to circumvent the trial court's orders regarding the documents she seeks from the third parties, and that she has delayed the proceedings, and that she has not sought the specific and narrowly tailored discovery from the former husband as she was instructed to do by the trial court. So court says, no, you can't ask for all that, narrow your subpoena or narrow your whatever to X, Y, or Z. This is the case that you can use to get a protective order if the party just says, yeah, whatever, and they basically reissue the same subpoena or don't do the narrowly tailored discovery. Also, this concept of delayed the proceedings, I thought was very interesting. So, asking for discovery late in a case when they could have asked for it beforehand, this may be a good data point to get a protective order if a party is delayed. Okay, and messing around with overbroad discovery requests. Okay, next case. Iati Enterprises versus Loyacano, Judge Asharte out of Miami-Dade County. I thought this was interesting because I don't think I'd ever known about this legal proposition that a non-party cannot be required to file a privilege log, period. This is what the trial court did, and the third DCA quoted from the rule and said, privilege log, if you're not a party, you cannot be compelled to file a privilege log. And this is an essential requirements of the law, which means interlocutory appeal, like reversal during the case. So the trial court departed from the essential requirements of the law and requiring Iati, a non-party, to file a privilege log. Okay, some criminal law cases. Not too many motions to suppress, but some interesting procedural stuff nonetheless. Moore versus State, Judges Cohen, Stuzan, and Lopez. This is the appellate panel because it was a misdemeanor case. So the defendant's husband was removed during defendant's testimony, and that was proper. And there was a really good exchange between the defense and the judge, but basically the court didn't want the husband's testimony tainted by being there during the spouse's testimony. I think this is applicable in the civil world too. Okay, next case, NC versus State, Judge Denaro out of Miami-Dade County. This is a resisting arrest without violence, and this conviction was overturned. So resisting arrest without violence. It was based on untruthful statements on one day, and that, like these untruthful statements, I'll read the quote, NC's untruthful statements regarding his identity on August 1st, when he was neither arrested nor detained, did not provide probable cause for his arrest or detention on August 2nd. So saying something untruthful about your identity does not get you a resisting arrest without violence conviction. Okay, next case, Wright versus State, Judge Fernandez out of Miami-Dade County. This was interesting to me. The trial court was not required to be present when the jury viewed the muted cell phone video during jury deliberations. Quoting from the case, the parties agreed that the jury could rewatch the cell phone video, but without the prejudicial audio portion. And still quoting from the case, it is entirely speculative whether the jury went against the trial court's explicit explanation that the video sound was not to be heard by the jury, and there's no evidence in the record that the jury heard any audio. The jury could watch a video without the judge there. I did not know that. Last part of the quote of this on this page. This is not a situation where the trial judge was required to be present at an aspect of the trial where the lawyers or the parties were in any contact with the jury or where the testimony was being heard requiring the defendant's waiver. Very interesting. Okay, next case, McWilliams versus State, Judge Bloomstein, Miami-Dade County. There were extrajudicial and in-court identifications, very horrible case. And there was only a single person in the lineup, but that was upheld if you're doing a lineup case. Next case, Gonzalez versus State, Judge Ziebler out of Miami-Dade County. Horrible facts, aggravated battery and armed kidnapping, but a new trial was warranted because the prosecutor used photographs of a glove found a week after the crime had been committed inside of a van that were not owned by the defendant. And so, quoting from the case, the prosecution tried to explain the lack of fingerprint and DNA evidence by pointing to the glove recovered from the van and suggesting that perpetrators must have used a glove or gloves to assure that no such evidence would be left at a crime scene. The prosecution told the jury, quote, "This glove just makes it more likely that these people were up to no good." So like this glove was in someone's van found a week later, and the prosecution like held up the glove and it's like, they're up to no good. Who wears gloves these days? This must be evidence of guilt. And the third DCA said, yeah, this is bad. We're going to overturn this trial. The state failed to present any evidence of a nexus between the glove and the charged offenses or Gonzalez. And the glove was more prejudicial than probative. Like, so this guy's DNA he wasn't connected to the glove. Okay, clearly there's nothing unlawful about keeping gloves in a car. And there was no direct connection between the glove and the crimes for which Gonzalez was charged. So I was blown away by this. A glove in a car a week later, therefore they must have done it, because who wears gloves? So this glove makes it more likely that these people were up to no good. I'm very happy that third DCA overturned that trial. Okay, next case, State versus Aaron. Judge Jones out of Monroe County. This is funny to read. So the court suppressed a blood draw because there was only one blood draw taken, and the warrant said there needed to be two blood draws taken. So because the police officers did not take two blood draws and only took one blood draw, the trial court suppressed the one blood draw. And the third DCA reversed, and the quote from the case is, "The trial court invalidated the warrant not because it was overbroad, giving the officers discretion to make an unconstitutional general search, but because the blood sample seized pursuant to the warrant was more limited than what the warrant permitted. We find no support for this position." Okay, next case, McCauley versus State, Judge Garcia out of Monroe County. I was happy to see this. There was a new trial required where the trial court excluded exculpatory evidence that another person confessed to committing the murders. So apparently this person named Lansford told the state attorney under oath that someone else had confessed to the crime, not McCauley, somebody else had done it. This is what Lansford said. But when Lansford was scheduled to be called as a third witness, quoting from the case in the defense case, on the day he was to testify, however, defense counsel advised the trial court that Lansford was refusing to appear because of fear for his life. He was going to testify that somebody else said they did the murders and he was scared. And the trial court said, well, we're just going to exclude that testimony. Like, we're not even going to hear about Lansford saying that somebody else committed the murder. And the third DCA overturned it and said Lansford's testimony taken under oath by a lead prosecutor for the state was potentially exculpatory and was promised by defense counsel in his summary presentation of the defense evidence and opening statement. Trial lawyers well know the effect on jurors of an unfulfilled promise to deliver a material element of proof, and the state hammered home that unfulfilled promise as it delivered its closing argument against McCauley. The reason why I'm glad to see it, I think juries should have all the evidence possible and make the decision. Stuff like this should not be withheld from a jury. So new trial required. Okay. David versus State, Judge Garcia out of Monroe County. There were some overreaching remarks by a prosecutor, and the argument, and this could apply also, I think, in a civil context. Prosecutor's argument in closing that the jury deliver, quote, a verdict that also speaks the truth and speaks justice for each of the individually named victims was fundamental error and required a new trial. These overreaching remarks, quoting from the case, were by design only intended to invoke sympathy and have been uniformly condemned. Okay, next case, AH versus State. It's kind of in the weeds of juvenile delinquency cases, which are different than criminal cases, but in any event, there was a sua sponte order by the trial court requiring a monitoring device, and the DJJ, which is the trial court usually looks to for recommendation, didn't recommend an electronic monitoring device, and the trial court's like, shouldn't we do a monitoring device? And the DJJ agreed, and there was an appeal like, hey, this is beyond what DJJ required, but the third DCA said, no, it makes sense. There were some pickup orders and there's other stuff going on. It's okay to put a monitoring device on a child like this. Okay, next case, San Sebastian versus State, Judge Tinkler out of Miami-Dade County. This person wanted to have an interpreter, and they claimed that you have to have an interpreter when anybody asks for it. And so the third DCA said the following: in the absence of any indication to the court that there may be a genuine language barrier, we decline San Sebastian's invitation to espouse a categorical rule requiring trial courts within the third district to inquire of every defendant regarding the need for an interpreter. So it's not on the trial court to like find out. It's got to be a genuine language barrier. Okay, Ryerson versus State, Judges Becker and Wilson out of Monroe County. There were some letters that the defendant was sending to the trial court. You see that sometimes. People, alleged criminal defendants send letters. Sometimes they file them, even if they're represented. And here, the third DCA said all that stuff that was sent to the judge, that's going to be inadmissible as plea negotiations. I thought this was interesting. Roberto Aguila and D.E. Poole versus Frederick. This is under the criminal case category because the trial court should not have compelled the disclosure of discovery relating to, quoting from the case, possession and use of a mobile phone during a crash that gave rise to a wrongful death lawsuit, because it violated the Fifth Amendment right to be free from self-incrimination. So people wanted to have like, hey, where were you when the crash happened? And the trial court should not have compelled the disclosure of that, because that's theoretically putting them, incriminating them, where they were when the crash happened. Okay, Warren versus State, there was no error in prosecution-friendly hypotheticals, but if you've sat through voir dire in a criminal case before, you'll hear a lot of different hypotheticals about what beyond a reasonable doubt means, and the third DCA kind of took issue with the cat eating a mouse in a box analogy and the Star Trek transporter and the Harry Potter spell. These are certain analogies that either the judge, the prosecution, or the defense will use to say like what beyond a reasonable doubt means. And the third DCA cautioned that such remarks carry the potential for confusion, a danger heightened by the fact that the remarks emanate from the bench. So I think interesting motions in limine that you can't use certain hypotheticals. Okay, next case, Ashley versus State, Judges Fernandez and Tinkler Mendez out of Miami-Dade County. This was error to require someone to take the witness stand just to invoke their Fifth Amendment privilege in front of the jury. That was like error. If you know that that's going to happen, you can't just make them sit up on the witness stand and take invoke their fifth and not say anything in front of the jury. Okay, next case, State versus Boykins, Judge Fernandez, Miami-Dade County. I thought this was interesting. The trial court required the state to produce an eyewitness for deposition, but the state did not have control of the eyewitness. And the third DCA said, there's no irreparable harm at this point, so we cannot grant certiorari and reverse the trial court. But if, quoting from the case, if the state fails or is unable to comply, leading the trial court to exclude the witness or impose some other sort of sanction, then we have irreparable harm. But right now, requiring the state to bring someone to a deposition that they don't have control over, we're not going to review that right now. Okay, here's some evidence cases. We have about 10 minutes left. I'm going to try to cram in a bunch in the next 10 minutes. Okay, the Waves versus Machado, Judge Diaz out of Miami-Dade County. There was a wrongful death at a hotel, and these people wanted to put in evidence that the victim had unquantifiable amounts of cocaine and benzodiazepine. And the third DCA said, yeah, that should have been excluded because they just tried to show that the victim had some unquantifiable amount of drugs in their system to, quote, do a character assassination. And another quote from the case, evidence of an unquantifiable trace amount of drugs can be excluded under Rule 403. Okay, next case, Union Carbide versus Font, Judge Rodriguez, Miami-Dade County. There was a new trial required because there were a bunch of affidavits that the plaintiff had that the trial court excluded. And they were affidavits regarding like when this person came into contact with asbestos on many different occasions. So good case for prior sworn statements really need to be introduced into evidence. Okay, next case, Williams versus Rita Food Corp, Judge Cinnamon out of Miami-Dade County. There was a slip and fall in a store, and there was summary judgment in favor of the store that the third DCA reversed. There's something called repudiation of your testimony. So sometimes someone will have a deposition being asked about certain things, and then as it relates to summary judgment, they'll try to backtrack an affidavit. There's a whole area of law on that. But here, what was stated in the affidavit after the deposition was not so inconsistent as to throw out like all the testimony, which is what the trial court did. So the trial court, quote, exceeded its authority in disregarding the affidavit. Okay, next case. CS versus State, Judge Denaro out of Miami-Dade County. This was about cell phone. The reason why I put this on evidence is that it could apply in civil cases as well. But basically, it was common knowledge that cell phone does not have depreciation that's material. So there was uncontroverted testimony that the phone was a certain purchase price, but the person who appealed said, well, wait a second, isn't there depreciation? And the third DCA said, well, the trial court can just, under common knowledge, know that cell phones are really valued about the same as you buy them. It's not like like a car where they go down significantly over time. I thought this was interesting. Certain items, you can just say common knowledge, no depreciation. Okay, next case, OJ McDuffie versus Uribe. I put it in there because OJ McDuffie, famous football player. Another doctor was not liable as a matter of law, but someone had said that that doctor was at fault. And OJ McDuffie said, wait a second, I should have been allowed to tell the trier of fact that someone said another doctor was at fault. And the third DCA said, no, because they were shielded from liability, it's irrelevant whether someone said they were at fault. I had a hard time getting my head around this being fair to Mr. McDuffie. And then there were some deposition designations from treating physicians that were properly admitted, even though it might have done a standard of care analysis. It's a good case for deposition designations. Okay, next case, State Farm versus Chirino. Judge Ige out of Miami-Dade County. There was an inspection of a house, and the party in lawsuit with State Farm wanted to video it and like record the appraiser, State Farm's appraiser. State Farm's like, no, you can't do that. You can't make a video. It's privacy, and you're going to intimidate the State Farm appraiser. And the third DCA said, no, there's no privacy. Mr. Chirino has the ability to be there. And then as far as intimidation, like where's your evidence of that? So you get to video an appraisal. Okay. Next set of cases are miscellaneous with about 5 minutes left. I'm not going to keep you past 2. So I'll go through these pretty quickly. And then you have the demonstrative if you want to keep looking. Humes versus Solansky, Judge Ruiz out of Miami-Dade County. There was some colorful language by a pro se litigant, and they were required to show cause why they need to be represented by counsel. So if you have an aggressive litigant, very good case to show why they need to have a lawyer. Next case, Hollander versus Adrian, Judge Ruiz out of Miami-Dade County. The litigation privilege does not apply as a defense to a lawsuit claiming an improper demand for maintenance dues. Hey, you owe maintenance dues, but if it's under like a false pretext, that's not litigation privilege. You can actually be sued for asking for maintenance dues when it's actual knowledge that it was fraudulent. Excuse me, that you had no basis to ask for the maintenance dues. Next case, Avell versus Sechrist, Judge Cinnamon out of Miami-Dade County. I thought this was neat. Ben Franklin was cited. Ben Franklin's adage, an ounce of prevention is worth a pound of cure. And here this pro se litigant did all the stuff on their own and then hired counsel to try to fix it, and just they messed the case up too badly. Settlement agreement and whatnot. Okay, Tallarico versus Tallarico, Judge Glick out of Miami-Dade County. There was an in-camera interview of children in modifying custody, parental custody, and the trial court didn't want to tell the parents like what the children said. And the third DCA said, no, you've got to, if you're going to modify custody and talk to the children in camera, you've got to say like what they said that caused you to modify the custody. Okay, Adcan versus Gotham Collection Services, Judge Santo Novenia out of Miami-Dade County. Another transcript case. The failure to include a transcript of the relevant proceedings is fatal, 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 fatal. Can't have an appeal. Get transcripts. Okay, Dumellaris versus Wilmington Trust, Judge Hansman out of Miami-Dade County. Bench trial court does not have to hold closing arguments. Bench trial, no closing, does not required. Jury trial, yes, not a bench trial. Next case, Miami-Dade County versus Miami Gardens Square One, Judge Butchko out of Miami-Dade County. The strip club said, hey, curfew, COVID, like don't enforce this COVID ordinance. We have a right to open our business. And they lost. They did not show a substantial likelihood of success on the merits in trying to enjoin the ordinance. Next case, Rodriguez versus Skirtis, Judge Santanovenia out of Miami-Dade County. Punitive damages standard. Usually it's really, if the court agrees with you, just really need to write the order that say what the standard is. But here the trial court did not say what the standard was. It just said met the requirements. So all they messed up with is just putting the magic words into this punitive damages order. So just track the statute and write exactly what the statute says as to why you're entitled to punitive damages. Here's the quote of what they wrote, and that wasn't enough. Scoopin versus Hemisphere Media, Judge Ige out of Miami-Dade County. We were talking about four corners cases and motions to dismiss before. Here, the issue was whether a hyperlink inside of the case, inside of the complaint, hyperlink inside of the complaint was, quote, within the four corners. And the third DCA said, yes, a hyperlink is part of the four corners. There was also some transcripts as well, but to me, the cool thing was the hyperlink. Hyperlink in a complaint, that brings out anything in the hyperlink as the four corners. Okay, Clarington versus State. This tested whether remote violation of probation hearings were constitutional. A lot of analysis. Violation of probation is in front of a judge. Criminal cases in front of cases in front of a jury. Judge probation hearings, you do have witnesses and evidence, but because of COVID, it's really hard to be in person. And here the third DC said, that's okay to do it remotely. We can do these over Zoom. We can do violation of probation over Zoom. Next case, Universal Property versus Desplande. This is a good case to oppose a motion for fees. 469 hours in a first property insurance case. Attorneys claimed to spend that much time. No discovery and no significant motions were litigated. There was next case, Santiago versus Leon, Judge Labora out of Miami-Dade County. It was creepy, but not criminal and not cyber stalking to send a bunch of emails and get a tattoo and mail packages and social media and make eye contact. Apparently that's not stalking. It's creepy, but not stalking. And last case, Ives versus Gettinger, Judge King out of Miami-Dade County. Good quote says, good fences make good neighbors. This person trespassed on its neighbor by hiring a construction company to remove sediment underneath the fence. Okay, that's 2 hours. This was a free 2-credit hour Florida Bar approved CLE. This is the number you need to get your credits on floridabar.org. This was about 120 out of over 600 opinions handed down by the 3rd DCA in the year 2020. If you want a copy of the demonstrative, send me an email, wizard@floridadcawizard.com or cullen@cullenobrienlaw.com. There were other free Florida Bar approved CLEs, 4th DCA case law developments from the 4th quarter of 2020. That's on YouTube here. 1 credit hour. If you want the demonstrative, email me. 2nd DCA year review of significant opinions 2020. That's on YouTube. 1 credit hour. If you want the demonstrative, email me here. 4th DCA year in review of significant opinions 2020. 2 credit hours. It's on YouTube. If you want the demonstrative, email me here. Email me here, wizard@floridadcawizard.com if you want information about other CLEs. And if you want to subscribe to what I do, it's $25 a month for 1 DCA real-time updates. It's $50 a month for all the DCAs and the Florida Supreme Court. And if you want to purchase all my summaries for any DCA, it's $250 a piece. Thank you very much. And I hope there's something here that's helpful to you in your practice. Bye.